Okay, guys, we're gonna get started. We still got people coming in here. Hopefully it doesn't get too noisy for you on Zoom because this mic picks up everything. And so when there's all this talking, sometimes it just shuts it off. So hopefully you guys can hear us good. Stewart Title is back here with us. Mark Chandler's been here a couple of times. Always love your trainings, very detailed, very thorough. I love this stuff.
Yes.
I picked it actually off the list.
Nice, yeah.
It's like, how that one.
We changed the fire prod, so.
Yeah, well, it's kind of coming more prevalent now, investing, creative financing, you're gonna come across it a lot more. In fact, I'm gonna do a creative financing class on April 5th. From some of the conversation that we've had in here, kind of start at the basic level on how to structure, who's involved, what kind of buyers, what kind of sellers participate in that, and what can go wrong. So I'm kind of prepping for that right now. But I'm gonna let Sherry come up here and just to introduce the title team. And I did email all of you that registered a link to a Google Drive for the PDF handout that we'll have here in person in the office, that you can pull that up. And yeah.
Great, thanks, Jeff, yeah. Well, hi, I'm Sherry Holmes with Stewart Title. I do marketing here in Salt Lake City. I brought a couple of the gals from our Midvale and Parley's office to introduce some products that we have at Stewart, but we do all the marketing, all the farm searching, tons of CE classes. So if I can help you guys build your business, please reach out to me. So Brooke, do you want to talk about certified for a minute?
I'm Brooke. I'm in Parley's office, escrow officer up there. We use a product called Certified, and we use it on every transaction. If funds are being wired in from a buyer, it does cost the buyer $5, but it ensures up to $1 million loss if there's any wire fraud, email hacking, things like that. We think it's well worth the money spent, and we will not, unless someone comes to closing, we'll just give hard wiring instructions, but we will not email those out. So just so you're aware, we take that very, very seriously. Also certified on your seller side, we're using it as a payoff protect when we order the payoffs, because there has been a title company that's been hacked on a payoff. They sent the funds and they thought they were sending it to the payoff lender and they never received it.
Oh, wow.
Money gone, never recovered. So that again ensures on the seller side, those funds that they will not be lost. If they do get hacked or wire fraud happens, again, really up to $1 million insurance on that money. So do you guys have any more holders?
Yes, yes, I am. Joni, do you want to introduce?
Hi, I'm Joni Simmons. I'm at our Union Park in the office. And just to kind of add to the certified ID, it's like it's been going on for a couple of years now, but it's even though you think wire fraud is becoming less and less, it's actually more and more. So it's really protective. But I think I just read something that we're going to start insuring hard money.
Yes,
Loan.
hard money loans as well.
The one that wires and stuff like that. So yeah, it's a great product. Well worth the $5. So, anyways, thanks for having us.
Yeah, thank you.
It's interesting, today's stock post gonna be on wire fraud. So that seems to be a thing. Look out for, we'll get that rescheduled. So,
Okay, for sure.
let you guys know.
Well, coming up, Mark, we have what, 32 classes that we teach, so if we can come back and educate you guys on any other topic.
We're not doing them all today, are we?
Not today,
Oh.
no,
Rapid
just
fire.
quick loss. I'm trying to.
That'd be too many.
Do you need any other information besides their license number for the?
I guess we're not gonna be doing the letters today, so yeah.
Probably not. I trust them. Do we trust the people?
Yeah.
Did you sort of qualify? Did you need one? No,
You use one a lot, so.
I usually, no,
You want me to pull up your PDF on here for you? Okay.
I'm fine. Hello, how's everybody doing?
Fantastic.
How are you? Good. What's your shoes? You never wear them, do you?
There.
Do you feel lighter and happier?
Yes.
Not having shoes on?
100%.
I'm thinking of taking mine off.
Yeah, you're welcome.
That would be.
Throw the socks in that one.
here for us. Yeah, thanks. We do have 32 classes. That's a lot. We need to get rid of some of those classes, right? Let me tell you about a couple of the new ones that we've done. I'm doing the mandatory residential course. And so we've submitted that for a credit. So we'll be doing that one. And then something that you said is interesting because I got a question about assumptions. So putting together a class on assumptions. I've got the outline done, so I'll be submitting that. Do you guys know about assumptions? So when you do, you know what I'm talking about? Mortgage assumption.
Assuming somebody else's law.
Mortgage assumption.
Assuming you're talking about assumptions.
Yes. Yeah, mortgage assumptions. And so, when you do seller financing and there's an underlying debt and you do an all-inclusive deed of trust, that's a form of an assumption, right? That's an informal assumption. Nobody's going to the lender, nobody's getting approved. And the original borrower is still on the hook for it. But with a formal assumption, you make buyer makes an application to the bank approves them, and then they take over the loan. And the advantages to the seller are that they are no longer responsible for the debt. So all of the legal responsibility is now on the buyer. Advantages to the buyer are pretty clear. You know, if you're at 6.5 or 5.5 or 6.5, and somebody's got a 2.5% loan and you can qualify for it. You know, get it. But the biggest disadvantage to the buyer is that you've got to come up with the rest of the money, unless you can figure out a way to borrow it. So if I buy a $600,000 house and it's got a $200,000 balance on it, I'm assuming that that's part of my consideration. But then I've got to come up with the rest of the money. And I may or may not be able to borrow it, depending on the lender, right? And so I think you're going to see more assumptions. We're starting to see a few. So anyway, that's talking about creative financing. That's just kind of an arrow in your quiver that you probably got to be aware of. So, so let me tell you about this class. Got a call from a broker quite a while ago, wanted to talk about wholesalers and wanted me to come into the office, and I thought, well, we'll go in and talk about wholesalers for 15 minutes. And 2 hours later, I thought, this is a class. And so, does anybody not know wholesalers? And we're not going to talk just about wholesalers, but you know who I'm talking about when I say wholesalers. By and large, unlicensed people, right? They're not required to be licensed. Unlicensed people, they go out and find largely distressed properties. They don't necessarily just focus on those, but distressed properties, and then they make offers that you know are cash. They will close within a week. They'll pay all the closing costs, and the property is as is condition, and so there's no appraisals, there's no inspections, and then they do one of two things. So they sell their contract. And so they assign it. So they'll find an ultimate buyer and they will assign it. And if they can't find somebody to assign the contract to, then they buy the property and flip it. Now, there are some, you know, that don't do either one, and they're the bad ones. And so not all wholesalers are created equal. So there are some real abuses out there. But so that kind of leads into the basic topic of an assignment. And so, has anybody ever seen an assignment of a contract, or you worked with an assignment? So let me give you a little background. So when you put a property under contract, so I'm a buyer, I put a property under contract. I acquire what is called an equitable interest in the property. And that equitable, there are several kind of counterparts or kind of interesting little wrinkles for what that equitable interest in the property means. But for our purposes, what it means is I can sell that equitable interest. So I'm not selling, obviously, the property. I'm selling my equitable interest that I've acquired in the property. And there is a market for it. So I can give whatever I can charge for it. And so these assignment fees sometimes range from $5,000 to, we've seen assignment fees of as much as $2 million. So it's a fairly lucrative business to be in. And there's a lot that goes into it. I'm going to teach you how to be a wholesaler, but you start with the basic premise that when you put a property under contract, you acquire an equitable interest in it, and that's marketable. You can sell that. Now, that's true of real estate contracts. And so the general rule for real estate contracts are that they are assignable. Personal services contracts are not assignable. So I hire you to paint my portrait. I'm hiring you for your expertise and for your experience and for your reputation. So I'm not going to be okay with you going to somebody else and saying, I'm going to assign you this contract, right? So personal services contracts are not assignable. Real property contract, real estate contracts are assignable. And that equitable interest has got some other few little wrinkles to it. And one of the things that these wholesalers do, and it's not illegal by any stretch of the imagination, in some circumstances it would be, but what they will often do is they will record a notice of interest on the property based on their equitable interest. So you guys all seen NOIs? And so a lot of NOIs, does anybody not know, never seen one or not know what I'm talking about? So a notice of interest is something that's recorded against the property by somebody that doesn't own it, obviously, that puts the world on notice. I'm making some sort of a claim. I have some sort of a position in this property. And the NOI is really only supposed to be used in the context where I am claiming under color of title some interest in the property. It's not to be used to secure a debt. So let's say that somebody owes you money, I borrow money from you and I don't pay you back, and so you put an NOI on my property. That would be illegal. The NOI is really only supposed to happen when a person is claiming an interest in a property. Let's say that I'm an inheritor, I'm an heir, and I think I'm getting cheated out of my inheritance. Maybe I put an NOI on the property. I'm going through a divorce and my name's not on title to the property and I don't want my spouse to sell it, without me being notified. So maybe I do an NOI on the property. So this equitable interest on the property that I acquire is, that's one of the areas where maybe an NOI is justified. It's called for, right? And so that's kind of a different topic, but.
So anybody that claims they have an interest can just go to the county recorders and just record it.
County recorder will record anything as long as it's the proper form, as long as it's executed, it's signed, it's notarized, it's got a legal description, and they will record it. And they won't ask any questions about it. So I could do an NOI on all of your properties. I won't, but I could.
So it's kind of like a lien then.
It's an encumbrance, but it isn't a lien. And the reason why it's not a lien is because it cannot be foreclosed.
Okay.
And so not all encumbrances are liens, but all liens are encumbrances. And so the difference is an encumbrance would be something like CCRs, right? Or a lease, or an easement, or a deed restriction. Those are all encumbrances on title, but they're there for a different purpose. Whereas the purpose of a lien is to give the lien holder the ability to force the sale of the property to get paid a debt, right? And that's sort of the difference.
So you can have an NOI that can just be on there forever if you don't sell the property.
It could be on there forever. It doesn't
Does it
expire.
disappear when you sell the property?
It doesn't disappear. And so.
So
that's why- Pardon me?
I've got a question.
Okay, go ahead.
So if I sign an NOI, most of them say right on there, they're not legally binding and there's a contract to follow. So you're saying if I sign an NOI on a property, they can record that, and let's say they don't fulfill their obligations and I want to move on, do I have to do something to get it released?
Yeah,
Or-
yeah, so when I say that there's there's some good wholesalers and some bad wholesalers. So what a wholesaler will do is they'll do it, not all of them do this. They'll do an NOI on a property to sort of hold the property hostage so the seller can't change their mind, right? Because once that's on there, then the seller, who who wants to, let's say that deal falls apart and the seller has another buyer for the property, they go to the title company's not gonna close that till that NOI is taken off of there. So if I'm a good wholesaler, if the transaction has fallen apart, I remove my NOI from the property. I should take it off. If I can't get it off, I have to, essentially, I have to sue to get it off of there, right? I have to sue to quiet title to take it off. There isn't another way to get it off.
Kind of like a stamp, like, hey, this could go legal. And unless things are resolved.
Yeah,
Well, what it does is it puts notice where the title company has to figure it out. They can't clear the title without it. It clouds it. It's kind of what they call it. And so they got to figure this out. So you had mentioned, hey, I could go put an NOI on all your properties. So let's say somebody just does it, like Don says, I got an interest. He does an NOI on my properties, like he has no interest. What would be the process to show that he really doesn't have that interest and get it?
if he won't take it off, you're gonna have to sue him. Now, there is a summary procedure. When I say a summary procedure, I mean a quick procedure. So because you've clouded my title, that's a really serious matter. And so what the law says is that I can sue you. If you do that, I can sue you. And without proving any damages, I can get $10,000 from you for a remedy. Now, if I can show actual damages, then I can get treble the actual damages. So I could get, if I have $100,000 worth of damages, I could get 300,000 in damages. So before you start putting things on people's properties, you always have to be really careful about it. And there is a summary procedure. So I don't have to go through the whole, because you could have a sale pending and it's a pretty serious matter. So I can actually get into court and get a declaratory judgment fairly quickly to get that thing taken off of there.
Yeah, if you didn't do that, then everybody just put NOIs on all properties on the MLS.
And there was a woman in San Francisco that did that. So she NOI'd all these properties. And so if you've got one of these on your property, right, what are your options? Because you want to sell your property, what are your options? Well, you've either got a sewer, or you're not going to sell your property, you're going to live with it, or you're going to pay her off, right? You're going to pay her some blood money. And so she walked off with millions of dollars before they caught up to her in Mexico and said, hey, that's kind of a scam. So don't be doing NOIs on properties. That's a little bit off topic.
So she collected money to remove it.
Yeah.
What about this remedy that I just made a note on that?
I don't know.
$10,000 damage.
We could have done it in California, but I don't know what the rules are in California.
Well, you gotta get a lawyer involved when
No.
that happens, and you gotta go through a process.
Yep.
And it's like, okay, do I want it done now, or do I want to go through this whole legal process? So let's just give you $5,000 right now and we're done.
The guy up in Ogden many years ago thought he had a commission problem, so he put an NOI on a property. That got turned in, to the board or to the division, and they just said, not right. So they fined him $1,000 and put him on probation. So don't do that, okay?
I was ready to go do it right now.
You didn't even know you could. Oh, great.
That one.
Yeah, great. Okay, so let's talk about assignments, and then we're going to talk about flips, and then the flops. What makes a transaction illegal or improper? Okay. So when I say that your real estate contract is assignable, let's talk about the state's REPC. Is the state's REPC or the division's REPC assignable? I gotta know
Not with the current clause.
I gotta
saying it's not.
know. It is assignable, not like it used to be assignable. And so you used to be able to assign a contract without any permission of the seller. So what people used to do is when they would write their REPCs, they would put the name of the buyer in there, and then they would put this language and or assigns. And the thinking was, by putting and or assigns language in the REPC, I'm putting the seller on notice, I intend to assign my contract. I'm doing a 1031 exchange. I put an exchange together this morning. And somebody on the REPC, they put the name of the buyer on it, and then they put and or nominee. Which I haven't seen in years, that kind of language. That language does not make the contract assignable. So don't use the and or assigns language. There are two conditions under which the states or the divisions REPC can be assigned. So it actually is assignable. But there's only two conditions under which it can be assigned. I'll give you the easy one, if the seller agrees. So if the seller signs an addendum, and there is an assignment addendum that says, I agree with this assignment. I will accept the assignment and I will sign an addendum signing it. Does anybody know what the other one is? So if the seller
For space
agrees,
planning purposes, like you have an entity.
yeah, so you can assign into an entity without the seller's permission. So if you put the property under contract and you have an LLC or an entity or a partnership, you can assign it into that entity. As long as you are a principal in the entity. So as long as you're a principal in the entity, you can do the assignment without the seller's permission.
What's
So those are
also
the
the
only two.
principle? How much interest in that
That's
entity do you have?
that's kind of an interesting question. Apparently 1%.
Oh, wow.
The REPC doesn't specify how much of an interest you have to have. So if you've got a 1% interest in an entity, you can assign them to it.
So if your question again, so if you're signing, you're okay to put and or assigns and then put in an addendum that you're striking that section of the REPC and this contract is assignable. That would be allowed, right?
Yeah, that would work. That would work. That would work. And what the REPC says that is if you do use the and or assigns language, it says that the only or that what that is referring to is one of the permissible assignments. So those two things are the permissible assignments.
So restate what he said about the clause. striking.
So the question was, well, first of all, you can't cross out any terms on the REPC. So you said cross out, right? That provision of the REPC. Does everybody know
Well,
that?
I just have to strike it like in an addendum, not cross it out, but just say this
Right,
section of the addendum is not relevant or something to that effect, right?
right. And that this contract is going to be assigned or it may be assigned. Yes, you use the addendum, you can do that. I've seen that before. You can't cross out or white out terms on the REPC, right? That's one of the no-nos. So, yeah, good question. Now these wholesalers, they don't use the state forms, right? Obviously, they don't use, some of them do, but they don't use the state forms. And so they're not agents, they're not licensed, and so they don't have to use the state forms. So they use their own forms, and it says right in their form that I'm going to assign it. And a lot of them say, put the seller on notice, I'm going to do an NOI on the property. So if you ever do think that it is appropriate to do an NOI on a property, I would have a conversation with the property owner, right? And make sure that they know that you're doing that. So in my new class, and then this is the last one I'm going to mention NOIs, and if I say it again, kick me. Yeah. You guys ever do lease options? So I got another class on lease options and seller financing. You ever do lease options? Yeah, you know what the problem with the lease options is for you from a practical standpoint? How you get paid, right? Unless you negotiate a way to get paid on negotiating the lease, you're going to have to wait for the option to get exercised before you get paid your commission. And so I have seen it where agents have said, well, how do I know when the option gets exercised? Well, you got to trust the people, but if you don't trust the people, maybe you do an NOI on the property. But I would never do that. I would never do that without the permission of the property owner.
Usually you'll get enough money up front as a down payment or the option premium, right, to pay your commission.
Well, that's in a perfect world, that's what happens. So whether it's a lease option or seller financing, the buyer's bringing in enough money to pay your commission and to pay closing costs. So, but that's another class. Okay,
Question, Mark,
go ahead.
could somebody in that situation, can you do a note in a trustee?
Yeah.
For your commission?
Yep, and I've seen people do that as well, which I think is a better way to go. So if you're gonna carry your commission, whether it's on a lease option or you've agreed to carry it because you've got a buyer that. Or a seller that's maybe saying, can I wait and pay you your commission when I do X, Y, Z? Yeah, you have that option, but I would always do a note. And then I would secure it with a trustee on the property.
And then that will also come with foreclosure rates, right?
Yeah. So. Has anybody ever done that? Yeah, did it work out okay? Yeah.
Well, there's the risk, you've got an option to buy the property at a certain amount, or let's say you're I'm looking at it as the person exercising the option. Two things could happen. You got the commitment needs to be paid, or you got a price to secure the option. If that person gets in financial difficulties, they might have other creditors coming after that property. Maybe they take out a second mortgage, or they do something that they want to, and it eliminates your equity or your position. Or maybe just judgments. They get judgments because they're not paying their bills. If you can't foreclose and wipe that off title, your position could be compromised.
It could be, yeah. And that's one of the downsides to doing the lease option. Most lease options, you wait 2 or 3 years maybe to exercise the option. But in the meantime, you don't own the property, and so you really don't control it. So if the owner of the property does have some liens or some issues on the property, then when you get around to exercising your option, that could be a real problem. Yeah, that's why I don't like lease options particularly, only in a limited number of circumstances. So I think you're almost always better off doing seller financing than a lease option. So, but that's right, that could happen. Okay, so have we already established you've not done an assignment, so you don't know about the UAR's form for the assignment? There's actually 2 forms for assignments, one for existing residential and one for new construction. And the new construction one came about back in 2006, 2007, because what was happening in 2006, prior to the recession, is that out-of-town buyers were coming into the state from Texas, Florida, California, and they were buying up a lot of new construction. They were putting a lot of new construction under contract, and they never had any intention of actually buying it. They were selling their contracts. And so, construction is going to take 6 months to a year. I put it under contract. That gives me a long time to find an ultimate buyer for that property. And so with assignments, there's always kind of these questions about whether you can do it, and whether it's legal. Because it is legal, but what kind of disclosures have to be made to the parties to the transaction? So if I have a contract that I'm selling for $50,000, I'm getting a $50,000 assignment fee. Do I have a legal obligation to tell the seller that I'm getting that much money on this assignment? And the answer is no. I don't have any obligation to disclose that. And if I did, it might not be in my best interest to do it, because if I've got a seller that says you're getting 50 grand for assigning this contract, I think I'm gonna default. Why don't I just go to whoever the assignee is and charge them 50 grand more or 40 grand more and get the property, sell them the property directly, and then I get the money. And so, it's kind of a tricky dance that you do, what you disclose. Now, the seller is going to know that you've assigned your contract, because somebody else is going to show up at the closing. And so they're definitely going to know. So I always think it's a good idea to let them know, so that there's not this angst at the closing. Well, what are you doing? What do you mean you've assigned it? Now, there's something that really should never be assigned. And that is if the seller has agreed to seller financing. If the seller has agreed to seller financing, why wouldn't it be appropriate to do an assignment of that?
Because they approved that purchaser.
That purchaser's credit is what you're relying on. And all purchases are not going to be equal when it comes to seller financing because you've got that credit issue. Whereas if it's a cash transaction, all cash is the same. I don't care whether this guy brings it in or this guy brings it in, as long as somebody brings it in, right? I really don't care. And so that all those questions about disclosures and everything else and kind of the messiness of the assignments is why the division just finally said, let's change the REPC. And so that's when they changed the REPC and said it's not assignable except for these two circumstances. Now, if you are a licensed real estate agent and you're a principal in a transaction, do you have to use the state approved forms? Does everybody understand the question? Let's say that you wanted to wholesale. You wanted to go be a wholesaler yourself and you wanted to try this, identify these properties, and then you wanted to sell your contracts. Do you have to use the state form?
I think so. We have to use them if we're representing the
Right.
public.
You only have to use it when you're acting in a representative capacity. So if you are a principal to the transaction, a buyer or a seller in the transaction, you do not have to use the forms. You can use whatever forms you want. They don't even have to be prepared by a lawyer. You can use whatever forms you want. What do you have to do though? That's bad grammar, right?
Disclose that you are.
Yeah, what do you have to disclose?
You're an agent.
You're an agent, but you have a license. Even if you have an inactive license, you have to disclose, you have an affirmative duty to disclose I'm an agent and this is the status of my license, it's active or it's inactive. And so that is an affirmative duty. You don't have to use the forms, but if you're an agent and you're a principal in a transaction, you have to disclose that. Okay,
Is that like
so,
that forever?
pardon me?
Is that like that forever? Like if you go inactive and you decide to never renew your license, is that still applicable?
Not if you're not a license, not an agent anymore, if your license has been withdrawn. Yeah,
You mean if it just perpetually is on inactive status and you're keeping up your CE credits, then you are.
then you have to disclose it, yeah. But
That's what
like I
that
said,
is.
many years ago, I had a real estate license, so I just let expire. I don't have to disclose that.
Okay, that's what I meant, is it
Yeah.
expiration?
Yep. Yep,
So if you're doing a land deal with a couple partners, you're just not putting on the NLS or anything, all you gotta do. We're negotiating with the owner. I'm an agent, but we're not gonna put this on the NLS. We're gonna buy this as a LLC or whatever.
you have to disclose it.
Yeah, you have to disclose that you're.
You have to disclose that you're an agent.
Right.
Yep.
Okay.
And the presumption is that you've got superior knowledge because you are licensed in the buying and selling of property. The presumption is that you have superior knowledge to the layperson. And that's the reason for that. Does anybody have any questions about that? Or about assignments? Now, here's a couple of interesting, we're not going to go through the forms. It's like Form 28 and 29, UAR Form 28 and 29. So if you can't sleep tonight, right, go through those forms. Or if you just want to see what they look like, go through those forms. There are a couple of things about them that are the same. So whether it's a residential assignment or a commercial or a new construction assignment, a couple of things that are the same, and then there are a couple of things that are different. So the things that are the same are maybe what you would expect to be in this assignment. And so when you do an assignment, all of the original terms stay exactly the same. You cannot renegotiate the contract because you have been assigned the contract. So everything stays the same. The purchase price stays the same. The closing conditions stay the same. Due diligence stays the same. Everything stays exactly the same. You can't change it. And that's true of both kinds of assignments, right? So we have had scenarios where we've got wholesalers who want to rewrite the contract. And so I'm buying for 200,000, I've got a $50,000 assignment fee, so now I've got a new contract for 250,000. So that the buyer is coming up with 250,000 as opposed to the original 200. That's not the way that it happens. And so that assignment fee is not a part of the original contract. And so the seller doesn't have anything to do with it. That assignment fee is a separate agreement between the original buyer and the new buyer. And it's got to be collected separately from the sales proceeds. Now, when I say that, title companies, some title companies don't like to do this, but Stewart doesn't have a problem with this. We're not saying you have to go through 2 closings. I'm not saying that you have to go through 1 closing between the buyer and the ultimate buyer to collect that $50,000. Right? That would be preferable. So what a title company would like is for the original buyer and the new buyer to negotiate outside of closing and take care of that transfer on their own. Most people don't like to do that. Most people want it done at the title company so that the title company is collecting the assignment fee and making sure the assignment fee gets back to the original buyer. Some title companies won't do that. I don't see a problem with it.
Question.
Go ahead.
Did you say earlier that you don't have to disclose that assignment fee?
No, you don't.
Because I used Stewart and they told me I did on a transaction. I thought there were case studies that in Utah required it now.
No, it kind of depends on the transaction. And so if it's a $2 million assignment fee,
Yeah.
we had one in our American Fork office where a couple of brokers found some property. They did the entitlements on it, meaning they got all the approvals for the subdivision, and then they sold it to a builder for $2 million.
Uh-huh.
That's a lot of hiding, right? I would not be comfortable not disclosing the assignment or having them disclose the assignment so that this seller knew exactly what they were doing with the property. Because I don't need any litigation, right? If you're talking $10,000, $15,000, $20,000, I don't see anybody suing anybody over that. And so I don't know in your scenario how much money you're talking about. If it was a big,
it was the one you were referring to.
Pardon me?
It was the one you were referring to.
It was what I was referring to.
Your example.
Yeah.
Where there was big money involved.
Yeah, it was out of the Spanish Fork office, but yeah, we did the entitlements. It was exactly what you just explained. So
Yeah. Hey, that was me. That's my fault. Did it turn out okay?
we ended up closing on it twice, so we didn't disclose.
And so that's the alternative. If you want to keep this secret, right? If you want to keep it secret, then don't do the assignment. Purchase the property because you've got a buyer on the other end, right? Purchase the property and then sell it for whatever you can get for it. Yeah, absolutely. So if you want it to not be disclosed, that would be an alternative. Or if you've got a seller that absolutely refuses to participate in it and they're saying, no, I won't sign any contract that you're going to assign, then maybe you're as opposed to an assignment, you're going to do a flip. Now we've got some developers who make that kind of money on assignments, and they always collect it on their own. And so they'll say, I don't want the title company to have to do it. We'll do it on our own. And that is really the best way to do it. Okay, so I'm glad yours turned out good. I'm glad I didn't name any names. I'm glad I didn't say these don't be brokers.
They didn't know.
Yeah. But apparently you did know what you were doing. So. Okay, let's see, what else do we need to cover? Also, when you do an assignment, everything stays the same. And the other thing that has to happen with an assignment is all of the money that the buyer is out of pocket gets reimbursed. So my earnest money gets reimbursed, my deposits, any down payments that I've made, the new buyer has to reimburse me all that. Now, the new construction assignment is kind of interesting. It just makes it very clear. The relationship between the original builder or the builder and the original buyer. It stays in place, and the new buyer does not have the ability to renegotiate with the builder for anything. Can't be going back and saying, I understand that, tile's been chosen and finishes have been chosen, but I want to change some stuff up. You can't change it. Once it's under contract, you can't change it. In fact, that assignment says, that form says that the new buyer can't even contact the builder. So if there is to be any contact with the builder, it's got to be between the original buyer and the builder. And so you can't start reinventing the transaction just because you've done an assignment. And then there's some other things in there. So, okay, anybody have any questions on that? Then we'll get into flips. So what's the difference between an assignment and a flip? Well, you did a flip, right? So you purchase, so the difference is you go ahead, the original buyer goes ahead and closes the property, acquires it, and then they resell it because they've got a buyer for it. And there's two kinds of flips. There's a simultaneous flip and there is a delayed flip. So most flips are delayed. So I'm going to buy the property at point A, got to rehab it, hold it for a little while, then I'm going to sell it at point B. You can, however, though, do a simultaneous close. So for instance, in your circumstance, you could have purchased the property and sold it on exactly the same day. There's nothing that says that you have to wait a certain length of time before you resell the property. In fact, and I don't think that you did this, but there's a form for that. So the UAR has a form called a simultaneous close addendum. So I don't like it. It's got some presumptions in it that I don't think work very well, but it is a simultaneous close addendum where everybody signs it and the seller signs it. So the seller understands, yeah, I understand that you're buying it, and then you're going to turn around and sell it. And you could do that on the very same day without having to wait. And so this is the flop part of the class. And this is where, if I had a whiteboard, it would be easier to illustrate.
I can get you.
No, let's imagine it. So I've got seller, I've got the seller, and I've got the buyer. Buyer number one. And I'm going to do a simultaneous close. And then I've got another transaction between buyer number one and buyer number two. Now, if I'm buyer number one, what I would really like to do, and this would be the gold standard for a flipper. The gold standard would for me to never have to come up with any of my own money. So how could I do this transaction without me ever having to come up with any of my own money? I'm the original buyer. How could I do this deal without me ever having to come up with my own money?
Money loan.
Well, I'm still going to have to borrow money. It's still my money.
Not if you borrow it from the end buyer.
Pardon me?
If you get your hard money loan from the end buyer.
Well, you're onto something. And so in a flipper's best scenario, you would use the second buyer's money to fund your transaction, right? So you would pass through the money from the ultimate buyer to the seller. So you never have to expose any of your own money. Well, title companies cannot close a transaction that way. So that's against the rules. So the insurance division says, no, you can't pass through stuff. So what has to happen is that first transaction has to close and it has to fund. So there's got to be money for it. And so as a real estate, and then that second transaction has to close and it has to fund. So they have to close independently of each other. And then title insurance has to be purchased for both transactions. So the seller buys a title policy for the original buyer. And then the original buyer turns around and buys a title policy for the ultimate buyer. And it kind of blows because it's a waste of a policy. Because your policy only lasts as long as you own the property. So let's say that the seller has bought an insurance policy for the original buyer. And then that same day, the original buyer turns around and sells to the ultimate buyer. That first policy is wasted. But it has to be issued. So the title company has to issue a policy. And the reason why it's wasted is because once I sell the property, that policy goes away. And so what these flippers would really like to do would be to pass through both things. So let's pass through the ultimate buyer's money to the seller, and let's pass through the seller's title insurance policy to the ultimate buyer. Can't be done.
So can you address Clint's comment though on he was saying instead of hard money, borrowing the money from the second buyer as a loan to do the first purchase? That's kind of a workaround.
Yeah,
it's still the second buyer's money.
Yeah, sure. If the second buyer is willing to do that, absolutely. And when I do my 1031 exchange class, I talk about kind of some real creative ways of using 1031 exchanges. And one of the, it's seller financing, when I teach my seller financing class. And so on that first transaction, right, where I've got a seller and I've got an original buyer, there's nothing that says that that seller can't do seller financing on that first leg of the transaction. Might cost you a little money. You know, are you guys willing to structure this as a 1031 exchange? Oh, excuse me. Are you guys willing to structure this as seller financing so that I don't have to come up with hard money, because hard money is expensive. And so that would be a creative use of seller financing. Maybe the seller says, yeah, I'll finance you for a day or two. It's going to cost you a couple $1,000. How do you feel about that? Well, pretty good, right? So I don't have 2-3 points I got to pay on hard money. And so that, you know, there's nothing that says how that financing has to be structured on that first leg of it. But yeah, the seller is willing, or the ultimate buyer is willing to do that because they've got the money. Absolutely, right? And most of these assignments are cash transactions anyway. What a bank is never going to do is they're never going to let you borrow the broker fee, right? They're never going to let you borrow over the appraised value of the property to generate the broker fee. That's really going to be cash coming out of the pocket of the person to whom the contract is being assigned. Does that make sense? The reason I got confused about the 1031 exchange, you guys do exchanges sometimes? So if I buy a $500,000, so I'm selling a $500,000 house and I've got $200,000 in debt on it, right? So I'm selling for $5, I've got $200 debt. How much money do I have to roll into my new property? 300. But what do I have to pay for the replacement property to do a 1031 exchange? I got to pay $5 for it. So you have to match your purchase price. So if I sell for $5, I got to buy for $5, but I don't have $5. I've only got $3. Where's that other $2 coming from? Well, it's got to be debt. So if I have debt on the property I'm selling, I have to have debt on the property I'm buying. But the IRS doesn't say where that debt comes from. And so if I've got a seller on my replacement property that is willing to carry that other 200 so that I have debt on it, that would be a use of seller financing in a 1031 to make it work. So just a couple of creative uses for seller financing. Okay, I think we covered it all. Go ahead.
Just with that carrying the debt over and the seller finance the debt on the 1031. Once that's all closed. Then it's recorded, you got that seller finance on it, then you can go and get a loan any way you want and you're good.
Well, you've got to have 500,000 available to put into your replacement property. And it's got to be 300 in cash and 200 in debt. So you really have to have the debt lined up before.
Right.
Or else you're not
You just want to
you're not gonna
refinance the
buy it.
$200,000 debt.
Yeah, come up with quick, like, hey, you know, seller finance for like 2 weeks while I secure these funds over here.
Yeah, people get really creative. People get really creative when it comes to that financing. Well, can I loan myself the money? I've got another entity. Can I loan
Yeah.
myself the money? Let's see, what was the last one I got? Lady wanted to do a partial exchange. I probably shouldn't get into this because I don't remember all of the details. So forget that I even started to talk about it. But
We'll just have to do a 1031 response.
my response is this, so on a 1031 exchange, you're dealing with the IRS. You don't want to get too creative. Because there's something called a step transaction, and a step transaction is a transaction which on paper looks just right. You've followed all of the rules on paper. But in reality, what you were doing is something really creative to kind of dodge the rules. And so if the IRS says on paper, this looks good, but you've sort of done something to dodge the rules, they could ding you. So you don't want to get too creative.
So technically, though, from what you're saying, if you did a seller finance, you own the property now. You just did your exchange, you own the property. You have the right to refinance it
Sure,
later.
yeah, absolutely. Yeah.
Okay.
If that was your question, yeah, absolutely. Yeah, so, yeah, do seller finance. Would you do seller financing for, a month? And let me get my financing in place and I'll pay you off? Sure, absolutely. Yep. Okay, I think I just talked about everything that's in the outline. One thing that I do want to stress on you is that if you're doing this kind of stuff, you really want to be careful. And I think that was probably a factor in my decision that you guys probably ought to not do a thing like that without disclosing it, because you're licensed real estate agents. And you have some different duties, right, as agents. So I think I cited a case in there involving the Haas companies many years ago, where they were doing something with flips. I forget if it was a flip or an assignment, and they didn't disclose it. And the seller guy really hacked off and sued him, and the court really went after him. So one of the guys, I think he had like $1.5 million in punitive damages against him. So if you can do it, disclose, right? Or do it the way that you did it. But when you are an agent, you're doing this kind of stuff, I just think you have a special duty to let everybody know what you're doing, to the extent that you feel okay about it. Okay.
You probably want to run it by a couple different agents or brokers too, to get some different opinions.
Yeah, probably.
I would.
Yeah.
I think when you're doing any of this, you call your title company for one and say,
Yeah.
I'm thinking about structuring it this way. Is this gonna fly?
Yeah.
That's a good idea.
Well, yeah, that's,
Your lenders that are involved are good, and then maybe if you have a different attorney.
Well,
you can work with it.
yeah, since you are disclosing at that point anyway.
Well, yeah,
Well, we've had some wholesalers that have tried to rewrite the contract so that it was originally a $200,000 purchase, and then they got a $50,000 assignment fee, and so they're rewriting the contract for $250,000. And we've had to say, no, we can't close that transaction, because you're doing essentially, without knowing that you're doing it, you're doing that thing that you can't do, which is you're using the ultimate buyer's money to finance the first transaction. So yeah, your title company is going to be a good resource to say, no, if you want to close this, this is the way you have to close it. And this is what your contract should look like. And then they can inform you, the title company does not have to collect that assignment fee. So they could say no. There are some title companies that just say, you do that outside of closing, you do it on your own, we won't collect it. I personally don't have a problem with it. And I've had people that have confronted me and said, yeah, you're doing that one thing that you're not supposed to do. Right, where you've got two simultaneous closings and you're doing pass-through of fees. No, this is not a simultaneous close on an assignment. It's one closing. You've got one seller and you've got one buyer. And I have no problem with that. Right? And now that I'm retired from Stewart, if Stewart gets in trouble for it, that's their problem. No, I care.
In full disclosure.
Yeah. So. Okay, guys, anything else?
Anybody on Zoom have questions?
We do have David Weekly Homes here to
Oh.
talk about a new project, so.
Yes.
I'll grab her real quick.
Yeah, thank you. Well, that's my now.
What, did you guys say you emailed something for CE or?
So there's an email address that you need to email Sherry for your CE credit. Send your brokerage and your license number to Sherry. There's no other information they need.
What's
other than they were
Sherry's
filed.
email?
So, we just reposted in the chat. Can you see the chat on your
Oh,
phone?
the chat.
Yep.
Let's see. Whoop. Yep. Let's see.
If you'll click on that.
There it is.
And the handout, there's a link for the handout that he was referring to in there too, if you wanted that for reference later.
Yeah, no, it's just this one right
Yeah.
here.
Yeah. So sherry.holmes, that's HOLMES at Stewart.com.
Okay, got it.
Okay,
Thank
cool.
you.
Okay,